So we're going to do the top 10 reasons closings are adjourned. And again, thanks to Richard for that very nice introduction and those kind words about Peter, who was my mentor. He was here when I started in May of 2001. My first daughter was born in September of 2001. We brought her home on September 11th of 2001, and it's been a wild ride ever since, both at home and in this industry. So we'll start with a quick introduction to the topic. Nobody wants to have a closing adjourned. There's a domino effect of adjournments. A lot of times the closing is tied together. It's a buy and a sell. Someone is selling something in New York and buying in, let's say, Florida or California. And if you're selling here and it adjourns, it's gonna screw up everything in the other jurisdiction, the other state. When a title company wins, we lose. That's kind of an inside joke. If we're right on the facts, we lose because the deal doesn't close and nobody gets paid. And title companies are businesses. We're not. We may make business decisions. We don't always go by just what the law says. You can be right on the law and still be a business decision where we need to say no. Unfortunately, we have to go by underwriting criteria. There's sales criteria versus mortgage criteria. Sometimes it's just because they said so, and judges don't insure titles. We go by recommended title practices, but they're recommended and not mandatory. And there's sometimes shifts in underwriting policies. We'll talk about that a little bit later. The background in the background of the title business, we have examiners, title examiners that go either online or actually go to the county clerk and examine files, examine titles, and then give it to a reader. And then we clear the titles, and you have insurable versus marketable title. And then we have something that's not even title related, but sometimes can really snag up a closing, which is certificate of occupancy and building violations and things of that nature, municipals, which is, Richard was talking about a little bit earlier. The searches themselves are hard to get, and then the searches themselves can disclose things that can adjourn a closing and cause a closing to take a long time to get to the table. Title insurance versus deed warranties. Upstate New York, everybody tells you to bring a warranty deed, which sometimes can take the place of title insurance in upstate New York. Down here, we do not do that. Everybody gets title insurance down here in downstate New York. You want a deep pocket. You don't want to have to go after a seller who's moved away and try to get money from a seller who no longer lives in the area. That's why you have a deep pocket, which is a title underwriter like First American or Fidelity or Old Republic. And we have fee insurance and mortgage insurance, as you know, the two different types, and we have a simultaneous rate. Sometimes the practical and not the legal issue can be the most devastating and cause an adjournment. No homeowners insurance, that would definitely stop a closing in its tracks, and missing a payoff letter. If you don't have a payoff letter and you can't get it, immediately, most banks will not get you a payoff letter immediately. We don't have local banks anymore. You can't just walk down to the branch and ask them for, your friendly local bank for a payoff letter for your mortgage. Federal tax liens, if you don't have a payoff letter for a federal tax lien, you're not going to close. No amount of money, is going to allow you to close. We're not going to be able to hold an escrow on a federal tax lien. You have to have a SAT or a payoff letter for that. Okay, now this presentation is going to, as I said, it's going to concentrate on adjournments based on statutory and case law, and you can't just throw money at everything, although we like to. Okay, reason number 10 on our top 10 list. An executor or an administrator gives a power of attorney to a third party. Can't do this. Fiduciaries cannot delegate their authority. The duty of a fiduciary is personal. For example, the decedent placed his trust in the appointed executor. He didn't want the executor giving that duty to someone else. They can delegate strictly ministerial duties. Um, they can act, an executor can execute the TP 584, can give it to a power of attorney, can delegate that duty by power of attorney, but the executor must sign the deed. And an executor who hires an assistant must be prepared to pay the assistant out of commissions, but not out of the estate funds. A fiduciary can resign. So a fiduciary who doesn't want to act or can't act can resign under the SCPA 715. So rather than giving a power of attorney, they can resign and get a substitute executor or administrator. Corporations, LLCs, they can do a power of attorney, but they don't use a power of attorney. They convey by attorney, in fact, using a specific resolution, corporate resolution or an LLC resolution appointing someone as a signatory. A lot of times it'll be the seller's attorney. So it'll make it nice and easy. Some important facts about powers of attorney. They have to be in recordable form because if you're signing a deed by power of attorney, it has to be recorded unless it's already recorded. It has to be recorded in the same county that we're conveying title in. Must be the durable short form. It terminates upon the death of the donor, obviously. If it's recorded, cannot be revoked unless the revocation is also recorded. So you'd have to record any revocation. You couldn't, if somebody was relying on it, you couldn't just revoke it in a separate document and not record that. There's a full force and effect that has to be filled out at closing. And because they are fiduciaries, technically any deed that's signed by power of attorney must recite full consideration. Okay, so this number 10, can this closing be saved? Unless the fiduciary is in close proximity to the closing, no, this closing will be adjourned. Okay, moving on. Reason number 9. Seller's attorney and his clients do not attend the closing, and the seller's closing documents never make it to the closing table. Okay, so post-COVID, we had COVID and we're on the other side of it, thank God now. But it changed the way we do closings a lot. Nobody comes to closings anymore. No sellers attorneys want to come to closings anymore. I know obviously it's an exaggeration, but it seems like nobody wants to come to closings anymore. Documents are usually sent to the title company to be held in escrow. The title closer, in that case, reluctantly becomes responsible for seller receiving their funds. FedEx is not always reliable, UPS, whatever, service you use. Thieves are stealing checks and documents. It happens. It's not guaranteed. They may not get there. Then you run into wires. When is the wire sent? Who's sending the wire? Who's in charge of it? Is the bank dispersing funds? Are they relying on the title company to disperse funds? Title company, if we're dispersing funds, are we the settlement agent? If we're the settlement agent, we're going to charge. We charge $1,500 to be settlement agent and produce a settlement statement. We don't do it for free. It's a lot of extra work. And also, people ask, why do you need clients and sellers attorneys will ask, why do you need original signatures, original documents even? Can't you close with copies, scanned PDF copies? No, because we sign an agreement with the county clerks that we have possession of the original documents, even though we're doing electronic recording, e-filing, e-recording. We sign an actual agreement saying we have possession of those original documents. So if we don't, we'd be lying, and that's not a good thing to be doing with the county clerk. So could this closing be saved? Yes. All parties, including the bank, must agree to escrow closing pending title company's receipt of original documents. So that's up to the title company, though. We got to have a good relationship with all the parties, knowing that these documents and the funds are actually going to get to the table. So it's good to have a good relationship with your title company. Because they don't have to agree to that. It's a business decision again. It's not always a cut and dried yes or no. Okay. Reason number 8. Now, I would call this the rookie mistake. The buyer and his attorney, the buyer is not aware that the bank is going to deduct closing costs of 10,000 and change, $10,017.60 in this case, from the mortgage proceeds of 200,000. Instead of having the full mortgage proceeds to give the seller, the buyer puts a personal check of $10,017.60 on the table. That's not going to work. As we know, the contract calls for certified funds for the balance of the purchase price. This is what's called the net proceeds trap. The solution, of course, is for the buyer's attorney to get the net proceeds amount that will be available to the buyer. This is not always as easy as it sounds. Sometimes it's difficult because the emailing mortgage docs and breakdowns from the bank attorney prior to closing. Sometimes they're getting you numbers very late. People are running to the bank. Buyers are running to the bank to get checks. You guys all know how this is. It's not easy. They're giving you totals late, and it's sometimes it's a guessing game. So if it's unavailable, that's exactly it. You can compute your own estimated net proceeds. So just get them close. And, with the GFE provided to the buyer. In this case, the amount due from the buyer has not changed, only the form in which it must be brought to closing. So he's still getting the same amount. It's just, he's got to bring a certified check. He can't be bringing a personal check in that amount. Could be malpractice for the seller's attorney to accept a personal check. I guess it could be. It could also relate to a seller's concession, could be addressed in this issue. This is where a purchase price is inflated to include a credit for repairs, which is often imaginary, resulting in 100% financing or more. This is okay if the bank is aware of the concession. Don't see these that much anymore. You do see them from time to time. I saw one recently. But again, they were more prevalent, 10, 15 years ago. If the bank is not aware of the bank attorney will be looking for the amount of the concession in certified funds from the buyer to the seller. Okay, now number 8, can this closing be saved? In the case of the net proceeds problem, the best thing that can happen is the parties and the attorney, they basically agree to wait, have a cup of coffee, like Peter said, while the buyer goes and gets certified funds. If not, the closing will have to be adjourned. In the case of an undisclosed seller's concession, the closing will certainly be adjourned if the bank doesn't know about it. Okay. Number 7. The executor of an unprobated will arrives at closing to execute the deed. No, without letters testamentary, this person has no standing. That's correct. If you haven't probated a will, it's a meaningless piece of paper. That's basically the plain language version of what I'm going to say. As we all know, the authority of an executor to convey real property comes out of the EPTL. It's all spelled out there. Basically, without letters testamentary, which comes out of the EPTL, section 11.11, and more specifically 11.11B 5B, they have no power of sale if they don't have the letters. You have to submit the will to probate, it has to be blessed by a judge, and the executor has to get letters testamentary. Now, a preliminary executor has the authority to convey real property as long as the letters they're given aren't limited. If they're limited and say restricted in some way that say they can't convey real property, then obviously they can't. Okay. As it says there, they have no power to dispose of any part of the estate before letters testamentary or preliminary letters are granted. And then we have the requirement, you'll see it as an exception in our Schedule B in the title report, that they have the letters testamentary or letters of administration in the case of an administration, have to be dated within 6 months. And that's not just for, or laughs. It's a reason. Under the SCPA, they have to be within 6 months. They go stale after 6 months. Section 703 states that letters testamentary or administration duly issued by the clerk shall be sufficient evidence of the existence of such letters and the identity of the fiduciary for all purposes for 6 months after the date of such issuance. Okay, now, can this closing be saved? Only if luck brings all the heirs of the decedent to the closing. They could then convey pursuant to an affidavit of heirship if the title company allows. And as we'll learn a little bit later, the title company is only going to allow if it's been 2 years from the date of death, because that's a new requirement under underwriting, which we'll discuss a little bit later too. The proceeds could be held in escrow until letters are obtained or to guarantee compliance with any of the terms of the will. But more than likely, this one is going to adjourn because chances are you're not going to have all the heirs available. Nowadays, people live all over the country. It's not like the old days where everybody stayed home and lived close by. Okay. Okay, we're all the way up to, we're cruising along here. Reason number 6. A religious corporation arrives at closing without a Supreme Court order or Attorney General approval authorizing the sale. No can do. Without such an order, this conveyance would be void. A religious corporation is more heavily regulated than a not-for-profit corporation, so the first step in the analysis of what is required is an examination of the organizational documents. Since September 1st of 1972, the not-for-profit corporation law applies to religious corporations. So in addition to a court approval, consent of 2/3 of the directors also must be obtained. A religious corporation shall not sell, mortgage, or lease for a term exceeding 5 years any of its real property without applying for and obtaining leave of the court. That's Religious Corporation Law, Section 12. And the intent of that law is to protect the congregation from the dissipation of church assets. And this requirement extends to the sale, lease, or mortgage of all property owned by the religious corporation, not merely property used as a place of worship. So not just the church itself, it's also the parsonage or any property the church owns. Okay, nothing in the statute prohibits a religious corporation from entering into a contract prior to court approval, however. So they don't have to have the court approval before they enter into the contract. But they have to condition the contract upon court order. If not, the purchaser's rights will remain intact. The court order must conform to all contract terms. So it's got to be very specific, this court order. Property acquired by a religious corporation, here's a carve out, at a foreclosure sale of a mortgage it holds, or a deed in lieu of foreclosure, does not require a court order for the subsequent sale or mortgage of that property. That's Religious Corporation Law 12, subsection 10. Okay. A mortgage also requires a court order for a church, for a religious corporation. Without it, the mortgage is unenforceable and cannot be foreclosed. A purchase money mortgage, however, does not require a court order. There must be strict compliance with the order approving the transaction. If the contract or mortgage terms are amended, so must the court order, and it's got to follow it completely, strictly. That's the Greek Orthodox Archdiocese case you see there. A title company will not insure the conveyance by a religious corporation without a court order. No escrow or undertaking to obtain a court order confirming the conveyance after the closing will be sufficient. I'm very confident that you can call around any title company, any reputable title company in the land, as they say, and nobody will be willing to insure that. They're not going to take a $500,000 escrow. They're not going to hold all the proceeds in escrow. They're not going to take your undertaking. They need that court order Too big of a risk. Okay. And the religious corporations are so closely related to not-for-profit corporations that we're going to take a look at the necessity for court orders for conveyances for them as well. There are four types of not-for-profit corporations, and only the type B or C require court orders for conveyances of all or substantially all of their property. But a title company is going to be conservative. We're usually conservative on these matters, most matters. A title company is going to always look for a court order unless we're convinced otherwise. So we take the conservative approach and let the seller's attorney tell us otherwise, show us otherwise that we're being too conservative. The difference from a religious corporation is that all conveyances by a religious corporation require a court order, but only a sale of all or substantially all of the assets for a not-for-profit requires a court order. And what is the court going to consider? They're going to consider fair price, best interest of the members, and they're going to look at not-for-profit corporation law 511(9)(b). And then another distinction between religious corporations and not-for-profits: mortgages by a not-for-profit corporation do not require a court order. And now, can this closing be saved? No, as I mentioned before, if there's no court order, the closing is going to be adjourned. There's no chance because we just don't know. The judge may never give that order. It's too big of a risk. And this is a business decision. You could argue with the underwriting counsel till you're blue in the face that it's just a pro forma thing that I have to do with the court. I just have to file a motion and I'm going to get it. We just can't take that risk. It's too big of a risk. What if it never happens? And then we'd have to explain to our underwriter why we let a sale go through without a court order. Okay. We're up to reason number 5. Seller arrives at closing with a payoff letter from a lender that shows legal fees due. Now, this is just from a lender, so it's from the bank itself. No, this means the seller is in default on his mortgage, and the payoff letter must come from the law firm handling the foreclosure. Okay, so we want to know the reason we want it from the law firm handling the foreclosures. We want to know all the legal fees are accounted for. Now, if they're on the payoff letter from the bank and it shows some legal fees, it might not be up to date. We don't know that the bank itself and the law firm handling the foreclosure are in constant contact. We don't know that those legal fees are up to date. So we want it from the law firm that's handling the foreclosure. We want that payoff letter from them. We need to know that we also need a secondary letter, or it could be part of the payoff letter from the foreclosure firm, stating that they're going to cancel the lis pendens. They're going to vacate the judgment, if there was a judgment of foreclosure and sale, and they're going to discontinue the action. We want a basically undertaking from that firm saying they'll do all those things. Okay. Then it also opens up to when it's in foreclosure, you open up the property and the deal to the Home Equity Theft Protection Act. That was enacted in February of 2007. It affects 295A of the banking law, section 265A of the real property law, and added a new section 1303 to the real property actions proceeding law. Okay, and you can see here an extensive list of what the act required. Basically, a lot of notice. Number one is the big one. You can cancel a contract within 5 days, and you receive a form to use to cancel it. Lots of descriptive language that needs to be used. Terms of any buyback or reconveyance agreement, things like that. If Spanish is in your primary language, the contract must be in Spanish. This is all dedicated. This was in This was done in response to equity theft, to people that were going into contracts with people, telling them they would buy the house or and reconvey it back after they got them. They would, take mortgage payments from them and get them straight on their mortgage, get them up to date on their mortgage, and then sell them back the house. Obviously, a scam. Okay, basically, the act would require all these things as you see listed out here. During the 5-day cancellation period, the buyer can't give the seller any payment or take a deed. The seller can't waive this. Buyback agreements allow the buyer to take ownership in return for bringing the mortgage current, which I was just saying. Then at a predetermined date, the seller repays the buyer and gets the house back. It's a scam. It's not something we can insure. Typical scam. Equity purchaser gets a deed promising the property will be reconveyed when the seller's credit is restored. The creditor refinances the property, cashes in, takes everything, takes all his equity, and walks away from the property. So they say the contract's got to be in 12-point print, 14-point print on different colored paper about a consumer education notice in a foreclosure. Act provides for both civil and criminal penalties, and the act is triggered by default in mortgage defined as arrears of 2 months. So we need a equity theft act affidavit if we've got arrears of 2 months or more. That's how we get around that. And it basically could prevent title insurance, as I was saying, because it allows the equity seller to cancel during that for 2 years after the recording of the deed. That makes it uninsured. So this pretty much killed those kind of deals, those equity purchaser deals. This was a very effective act. It affected 1 to 4 family dwellings that were not owner occupied. So had to be owned by a natural person to come within the act. And then you had your exemptions. If the purchaser was using the act as a primary residence, it was exempt. Deed from a referee was exempt. Pursuant to a court order. Deed from a spouse, parent, grandparent, that kind of thing, parents, family. Not-for-profit housing organization, and a bona fide purchaser or encumbrancer for value. Now, back to that payoff letter. The payoff letter in a foreclosure has got to be from a law firm handling the foreclosure to ensure all legal fees are paid. And it's got to have that undertaking to cancel the list pendants and discontinue the foreclosure action. Now, can this closing be saved? No, such titles are insurable. That's referring to the one that was the equity purchaser. We can't insure those. The one where it's with the buyback in the contract. We cannot insure those. Those are no good. Foreclosures, we can insure. Obviously, we do it all the time. As long as we have the right payoff letter, as long as we have the legal fees and the undertaking from the foreclosure firm stating that they'll cancel the list pendants and discontinue the foreclosure action. As long as we know they're going to do that once they get paid the full amount, then we're good to go on a foreclosure. Okay. Up to number 4. The intestate deceased owner's daughter who lives in the house arrives at the closing to execute the deed. No. Either an administrator or all the heirs must convey the property. Okay, so the daughter shows up with no letters of administration. The father had no will, so she shows up just saying that she's going to sign the deed. She admits that she has a brother, but states that he has no interest in the property. What she means is that he's not interested in the property, like he doesn't want anything out of it, but obviously he has a legal interest. And all the intestate heirs have an interest that must be disposed of at closing by execution of the deed. Obviously, we know what an administration is, where a decedent leaves no will. He's determined to die intestate, and we have a fiduciary known as an administrator that's appointed. they get letters of administration, which are like letters of, letters executor, but they state that they can sell the real property. A bond has to be filed in the amount of the sales price unless all of the intestate heirs waive. They can waive in the administration proceeding. They can waive that requirement. So if it's waived, we don't need that bond. Where there are no heirs, the people of the state of New York become the owners, and only the public administrator can convey. Okay. Now, title companies and surrogates courts generally do not force simple estates through the expense and time of an administration proceeding, but will accept an affidavit of heirship to convey title. Now, this used to be the case more frequently. We used to, in the beginning of my career, we took heirship affidavits all the time because the surrogates court would say, no, you're just selling a house. That's all you have in your estate. We're not going to make you do an administration. However, within the last, I want to say 5 to 10 years, I don't remember exactly when they changed this, but it was within the last 5 to 10 years. Most of the major underwriters, if not all of them, stated that they want 2 years to pass. The decedent must have died within 2 years or more, before we can take an affidavit of heirship. And that's because there's statutory period. Basically, statute states that once the 2-year period has passed, no one can come out of the woodwork and claim that they took under a will. Okay, so by simple estates, we're talking about a spouse and children, heirs in the direct line, as opposed to, extended family, uncles, nieces, that kind of thing. Obviously, you need proof of death certificate, not an affidavit. I don't want an affidavit. I don't want a picture of a headstone. I want a death certificate for the person, for the decedent, and he or she must have died more than 2 years ago. We need to know there was no will, or if there was a will, there were only monetary bequests, and no conflicting specific devise. The property couldn't be left to someone specifically. If it was left to all the heirs, then that's fine. Again, if it's only the house that's in the estate, if it's the only asset of the estate, the courts and title companies don't have to make you probate the will. Also, proof that none of the heirs are minors or under a disability. Is there a guardian appointed for someone? Then we've got to get the guardian involved, and that makes it obviously much more difficult. Peter always used to say to me, affidavits of heirship are fine because what is an administration? It's just a glorified affidavit of heirship that's blessed by a judge. But we do want something blessed by a judge because, then it's been given the thorough review of the court, so we take that when we can get it, obviously. Okay. This is just more background and more, this case law about how, we can do intestacy through affidavits of heirship because, you've got case law saying intestacy's decedents' real property devolves by operation of law to their distributees at the time of death. They can act without the necessity of subjecting the estate to the burden of an administration proceeding. So that's a 1988 Nassau County surrogates case, basically backing up what the surrogates clerks are saying. We don't want to burden them with the cost and the time of bringing a proceeding when we can just do affidavits. But again, we want that, a deed delivered more than 2 years after the death of the owner, because under the EPTL 3.3-3.8, the heirs will not be affected. A deed from the statutory heirs will not be affected by a testamentary disposition of the real property. However, not disclosing a long-lost sibling or heir can lead to a title claim, having to defend a claim for a share of the sale of the real property, and those are real claims. We have gotten them here. and they are not fun. They're expensive. Um, the same holds true for an executor appointed in another state. A title company will not require ancillary letters to sell real property if an affidavit of heirship is an acceptable substitute, and 2 years have passed since the date of death of the owner. That's a little trickier. I'd want to look at that one a little closer myself, actually. Can this closing be saved? No. All the heirs must be present and execute the deed. And in this case, they're not. The case we were just talking about. Okay. Shifting gears. Reason number 3. A seller with a docketed judgment against him, discharged in bankruptcy, believes he can sell the real property free of that judgment. No, there are 2 parts to a judgment, a debt and a lien. Bankruptcy, a discharge in bankruptcy only discharges the debt. Okay, this is one of the most frustrating phone calls or emails that you have to have with a seller's attorney. Okay, background. Bankruptcy is a federal law, obviously. Got rid of debtors' prisons, thank God. It's 2 separate types. Chapter 7 is liquidation. 11, 12, and 13 are reorganization. We deal mostly with 7s. Liquidation. The rules specifically state, they state that the bankruptcy petition is supposed to be filed in the county clerk's office. It's never done. We're only technically responsible if the petition is actually filed in the clerk's office. However, as you know from your title bills, we perform bankruptcy searches in the Southern and Eastern District mostly. And by running those independent searches, we have extended our liability and must deal with the findings. So, we do it to see if there were any filings in either the Southern or Eastern District. And the issue here is judgments against a discharged debtor. So the debtor went all the way to discharge. However, the judgment has been discharged. How can it still be a lien? It's still a lien because there are 2 parts to that judgment. There is a debt and there is a lien. In bankruptcy, a discharge gets rid of the debt. It does not get rid of the lien. What you have to do is make a motion in bankruptcy court to avoid the lien. I've seen it done many times, but most of the time it's not done to avoid the lien. It's a specific motion in bankruptcy court when they're doing the discharge to remove the lien against the real property. In some cases cited. A qualified discharge, as distinguished from an unqualified discharge, serves as notice to third parties that despite the debtor owner's discharge in bankruptcy, property may still be burdened by any liens. Excuse me. Despite homestead exemption, a lien against the exempt realty remains valid unless the debtor takes affirmative steps to avoid the lien by making an appropriate application under federal bankruptcy law. And that's under 11 U.S.C. section 522. You see it there. These sections and an order are attached, so you can see that. And again, Peter thought it was possible malpractice not to go that easy extra step in a bankruptcy proceeding. I've seen motions for it, and it doesn't seem that hard. I don't know why they're not done as a matter of course. A motion to avoid the lien in the bankruptcy proceeding. That gets rid of the debt and the lien and kills the judgment. There's a Bank of New York case that was cited earlier. That shows you that that gives you the meaning of the section 150 of the New York debtor creditor law. That is a post-discharge proceeding. So that's another remedy you can use if you don't want to go back into bankruptcy court. If you have a judgment that was discharged in bankruptcy, but not a lien, where the lien wasn't avoided, you can go back into New York. You can go into New York state court under section 150 of the debtor creditor law and get an unqualified discharge that way. It's a corrective remedy for failure to avoid the lien. And the standing to seek that unqualified discharge in state court is broad. So the buyer could even go. The purchaser from the discharge debtor could go and do that. Now, what are we going to want? If we're at a closing and you've got this judgment, we're going to want that order avoiding the lien, or we're going to want an order pursuant to Section 150 of the debtor creditor law. Now, if you don't have either of those things, we're going to hold probably double the judgment amount. If it's a big judgment, maybe 1.5 times. Or we could hold the amount that it would, an attorney would charge to bring those actions. Just enough to make sure, that we can get that action done. An undertaking along with that to get it done. Of course, that judgment must be of record prior to the commencement of the bankruptcy action. And if the bankruptcy action is dismissed, so he doesn't get a discharge, it's just dismissed, that doesn't get rid of the debt nor the lien. Okay, so that qualified discharge, where all it's doing is basically telling us that, putting us on notice that the lien still exists. So, and it's a lot to wrap your head around for sellers' attorneys a lot of times. And Bank of New York case also affirms the fresh start philosophy of the bankruptcy law. And it's, it's a good thing. Maybe most creditors don't like it, but it allows a discharged debtor to purchase new real property, unhampered by the pressure and discouragement of pre-existing debt. It's 20 years ago now already that the Bankruptcy Abuse Prevention and Consumer Protection Act of 2005 was the new bankruptcy law back in 2005. Few changes that affected real estate. Automatic stay was easier for banks to lift. Definition of transfer now includes the creation of a lien, and fraudulent transfers was expanded. Can this closing be saved with that qualified versus unqualified discharge? Yes, but only if there's enough money in the closing to deposit escrows on such judgments. Okay.
Before we get to reason number 2, I'm going to give the course code. The course code is closing. The course code is closing.
Thanks. Okay, we're almost done. 2 to go. Number 2, a probated will results in letters testamentary issued to 2 executors, but only one attends the closing to execute the deed. Not good. Where there are only 2 executors appointed, both must execute the deed. The statute is clear. Where there are 2 fiduciaries, action must be unanimous. Where there are 3 or more, a majority is required. So if you have 3 or more and one disagrees with the action in the majority, he or she will be relieved of their liability even if they join the action and if he expresses their dissent in writing. As we know from reason number 10, a fiduciary cannot delegate their authority. So where 2 executors are appointed, a power of attorney from one to the other will not help. So both executors have to sign the deed. It's not a ministerial act. I mean, pretty simply, they have to have valid letters of testamentary, or if they're administrators, they have to have valid letters of administration. Just pre-sign the deed. If you want, I have people that say, "Oh, I want to give power of attorney to my executor." Wants to give power of attorney. If they can sign a power of attorney, they can sign a deed. Just sign the deed ahead of time. There's nothing wrong with doing that. FedEx to them, have them sign it. If they're in California, have them sign it there, send it back. It's not that, it's not that big of a deal. Then if let's say it did happen though, and you had only one sign, by statute, a deed executed by one or more, but not all of the executors have been appointed, will become valid after 10 years if it's been recorded. 10 years after recording. Okay. When we have a deceased person, the title company is going to ask for proof of payment of New York and federal estate taxes. You all know that. You see that in your title report. Whenever you have deceased people coming out of an estate, New York estate taxes are a lien for 15 years, federal for 10. We're going to want either a release of lien or an affidavit that the estate is under the exemption amount for that year. Although title companies accept self-serving affidavits all the time. Obviously, if the purchase price of the house is $10 million, an affidavit that the gross estate is insufficient might not be accepted. A surviving joint tenant or tenant by the entirety can convey to a bona fide purchaser free of the lien of estate taxes. And as of this year, the exemption is all the way up to $13.99 million. So I guess you'd have to have a $15 million house for us to start, wondering if an affidavit is no good. Can this closing be saved? Not unless the other executor is readily available. So again, this probably wouldn't be saved because people are all over the country now. They're not, people aren't local anymore. A lot of times. Okay, reason number one. A probated will names the specific devisee, but the executor attends the closing to execute the deed. No, the executor has lost the power of sale. Only the specific devisee can convey this property. As previously discussed, the authority of an executor to convey stems from EPTL 11-1.1, etc. With respect to any property or any estate therein owned by an estate or trust, except where such property or any estate therein is specifically devised. Okay, to sell the same at public or private sale. So they giveth and they taketh away. If it's specifically devised, the executor has no power of sale over that property. Okay, so sorry. It's a common error resulting from a failure to closely read the powers of fiduciaries statute. As the statute gives the executor power to sell real property, so it does take it away, except where such property or any estate therein is specifically disposed of. So it's got to be specific. Where it reads, I give my house at 123 Fifth Avenue to Mary Brown, that's a specific devise. And only Mary Brown can convey this property. In the instance where a specific devisee is also the executor, the deed must be clear that the conveyance is made in an individual capacity. It would be wrong and ineffective to convey by using an executor's deed. A residuary devisee, in contrast, is not a specific devisee. A specific devisee is a disposition of a specified or identified item of the testator's property. EPTL 1-2.17, that is. So it's got to be specific. It can't be all my real property. It can't be, it's got to be my house at, or my real property at. Sometimes it's not always to determine the extent of the devise. In the example above, I give my house to 123 Fifth Avenue to Mary Brown. Does that wording include the land or a detached garage? The cases are clear that such a devise does include the land and all the accessory buildings. In such will construction, matters of intention of the testator are paramount. Cases in connection with the interpretation of specific devisees look to the date of the execution of the will rather than the date of death as the testator. When words such as together with, also, as well as, or known as appear in a residuary clause, followed by a specifically identified piece of real property, title companies require both the executor and the residuary devisee to execute a deed in order to safely resolve the ambiguity. So again, what are we going to do? The title company, we're conservative. We're going to take the conservative approach. We're going to ask for both the executor and the devisee. A specific devisee's title vests at the moment of death, subject to the successful probate of the will. So then judgments against the specific devisee attaches liens against the property on the date of death. So once that will is probated, once that person has died, judgment creditor has a claim against their share of the property. Can this closing be saved? No, unless the executor also happens to be the specific devisee, which sometimes can be the case. You'd have to be very lucky, though. Okay, we're going to wrap this up. Closing world after COVID-19. The title company acting for the seller's attorney, a lot. We're holding documents in escrow. We're accepting wires. We're dispersing funds. We're getting checks and running them to the seller's attorneys. It's common stuff now after COVID. COVID really shook up the real estate practice. Is it really a closing if no one attends? It's a good question. Power of attorney, originals versus copies. Again, we need originals. We are telling the county clerks that we are submitting, when we're doing e-filing and e-recording, that we have the original documents. Escrow agreements, original loan documents, and assignments. Again, we're going on the hook for having these originals. We have to get the originals. PDFs are not enough. We may close with a PDF if with an undertaking that we are getting the originals, but we want to see a FedEx slip and we want to know they're coming. We might not accept an attorney's undertaking if we don't know the attorney well enough, and we have, or we do well know them well enough, and we don't have a good opinion of them. We might not take their undertaking. Who is dispersing funds? Again, if we're dispersing funds, we're acting as settlement agent. We charge a fee to do that. We don't work for free. And the mail closing, everybody's favorite, becomes a multi-day closing. They're never done in one day, very rarely. It's at least a 2-3 day event. Okay. That's pretty much it. And I'm going to look to Diana now for questions because she knows how to do that better than I do.
All right, so we'll just, the lecture is formally over. We'll get to a couple questions. Anything we don't get to, if we don't get to your question, you can shoot Charles an email and he will get back to you. So these two questions came in on that last slide. With regard to specifically devised real property, what if the property must be sold to pay estate bills? Title vests in divisi to the estate bills. If they sell the property, how do the proceeds go back to the estate?
Ooh, that's a good question. Property must be sold to pay estate bills. Well, I mean, the intent of the testator was to give the property to the devizee. You have a conflict there. Property must be sold to pay the estate bills. That is a good question. Who asked that question?
I'll send you the
Send me and yeah, I want to get back to on that because that's a tough one. That's a conflict. I mean, the testator's intent was to give it to this specific person for their, enjoyment, their use and enjoyment. Yeah, that's a good question.
And then for the last slide also, it says, I'm assuming the executor can sign the deed to convey it to the devizee.
No, there's no deed to the devizee. A specific devizee comes into title as soon as that will is probated. There's no deed needed into the specific devizee. The devizee can sell. We certify title in the specific devizee once we see that deed with the specific devise.
Okay. And we had a couple questions come in on reason number 2.
Okay.
Hold on, because they were being asked in the Q&A and the chat box. So if one of the executors has passed away, can you bring the death certificate and proceed?
No, because you have to have a formal, you'd have to have a formal either you have to have something formal in surrogate's court, either a new substitute executor or new letters just appointing that one executor.
Okay. Would majority rule also apply to sale by a trust, 3 trustees and only 2 sign deed at closing?
Yes.
Okay. One other question. What happens if the mortgagee is no longer alive, having died after the signing of the contract, with no surrogates courts proceeding, or the financial institution is out of business? I think that was asked earlier in the lecture around reason 8 or 9.
I'm not sure the context of that. Let's see. Let me go to 8 or 9. 8 or 9. Nine probably. No, 9 is not. No. Let's see. Read that question to me again?
What happens if the mortgagee is no longer alive, having died after the signing of the contract?
Mortgagee is no longer alive after the signing of the contract. I believe the estate would have to come into play because their responsibilities would still be would survive the contract. Yeah, that's my gut on it without looking it up.
Sounds good. And one other person also wants to know about the estate debts as well. I'll send you those too. But
Yeah,
in the interest of ending sort of on time,
yeah,
so that will be the last question for now. And if you have any specific questions, you can email Charles and he
yeah.
will answer you.
No, I'm
Thank you
available.
everyone for coming. Enjoy the rest of your summer and we will see you in September.
Thank you.